this was a relatively quick process for this jury to convict him of corruption. There is a pull between that and a realization that this man has already lost so much. He's lost his money, he's lost his reputation, he's lost his family in great respects. How does that weigh in? Does the judge take into account how much the Governor McDonnell has already suffered?
I think he should, yes. That's certainly an argument that is made in situations like this, that the defendant has been punished significantly already by the things you've mentioned, the loss of family, reputation, prestige. So that should be factored in by the court into the punishment. The judge has to look at all of these things, the weight of the evidence, the severity of the offenses, the good character of the defendant himself, what he's already lost. All that goes into the mix. The federal sentencing formula for the actual sentence is a multi-factored statute, a law that sets out a number of factors, including but not limited to what the guidelines recommend. But as a practical matter, the guidelines are still, in my experience, the single most important factor in the case in terms of what will guide the judge's sentence.
Have you ever seen a case where you've just been floored by how low a sentence it was by a federal judge? In all your vast experience, you went, wow, you really got lucky today.
Well, I have had some clients who cooperated with the authorities, pled guilty, cooperated.
He didn't do that.
And have received what I felt were very lenient sentences, as they should have received for what they did. As far as someone who has not pled guilty and cooperated, someone who's gone to trial, who has run the gauntlet as they have a right to and exercised all of their rights, it's difficult to think of a case where there's been a substantial departure downward from the guidelines. I have seen some departures where the court did not give what the minimum guidelines required, but the variance down from that has not been anything like what the governor's attorneys have sought in this case.
Is there anything that you want to give us as far as experience like with the Bank of the Commonwealth? That's like something that recently happened. You were involved in that,
yes,
dealing with the federal court and the sentence that was handed down. I'm sure you argued all these things for...
We did. I think as you alluded to earlier, the court is going to be under a lot of pressure because of who this defendant is, not to do something that appears aberrant because of who he is. In addition, it is a public official. He has been convicted of public corruption, and courts do try to send messages in those kinds of cases. So I think that's going to shape a lot of what the judge does as well in terms of how he views this. I think that's going to make probably the biggest difference in the case.
Everything you've said is not boding well for Bob McDonnell.
Well, I think that federal sentencing is strict. It is difficult to get departures downward from the guidelines. It happens, but even though they're only advisory, it's not easy. He has been convicted of multiple counts. He is a public official. The weight of the evidence, the judge has passed on that already. They've filed motions to set aside the verdict. And again, I think because of the message that the court probably needs to send, it's going to make it difficult to get a sentence much lower than what the guidelines recommend.
The fact that Johnny Williams got a sweetheart deal, not only he was given total immunity in this case, but also immunity in an unrelated stock shareholder lawsuit against him, where they said you can't prosecute him now because we need him for this McDonnell trial, and he's basically walking away from both. Does that does that play in favor of McDonnell getting a lower sentence because the government had to give away so much in order to get the convictions?
I don't think so. I think it's apples and oranges. The judge knows the government has the discretion, what we call prosecutorial discretion, to prosecute one person but immunize another, depending on what their needs are in terms of evidence. That's really up to them. I don't think that in this case the court is going to look at what Johnny Williams received and in some way temper the sentence. Now, in cases where there are multiple defendants, as we do have here, there's a husband and a wife, judges do try to keep the sentences proportionate to each other, depending on each one's position in the case and their degree of culpability. So that may have some bearing. What the court's thinking is on the co-defendant sentence, although that hasn't really come to maturity yet. Judges do try to keep sentences proportionate amongst defendants, but as far as someone who's been immunized, no, I don't think that's going to have anything to do with the outcome tomorrow.
You also represented Phil Hamilton, right?
I did.
Early on, but not
I
at
did.
the end?
Well, I represented him in the trial, not on appeal. But I will say, in the Hamilton case, that is an example of a case where the guidelines were actually higher than his ultimate sentence. The judge in that case, Judge Hudson, did depart downward approximately, as I recall, about 1.5 years off of what the bottom end of the guidelines recommended. So that's an example of how a judge, in some cases, even cases of this type, might feel because of a defendant's good record and good background, they are deserving of some consideration.
Because he got 9.5 years.
Yes.
Right? 9.5. So what did Hudson give him?
That's what he was given by the court, the 9.5. As I recall, I think the guidelines were closer to 11 and above, as I recall, something in that range. And my impression is that he got about 1.5 years lower than the bottom end of the guidelines. And so that, you might see that tomorrow. There, because of the exceptional good character, that's a weighty factor as well. The judge conceivably could go down a couple of years from that 10-year bottom end and perhaps feel like he's still serving all the factors that he needs to serve.
How low of a sentence would Bob McDonnell have to get? Because you know he's asked for community service. You know he's asked for that. He's not going to get that.
I would be very surprised.
So how low of a sentence does he get where he's actually got to think, gosh, do I appeal this? How low would that have to be?
Well, I think
because your risk is that maybe you get a worse sentence.
Well, that's actually there are certain constitutional limitations on getting a higher sentence if you win your appeal. It can happen theoretically, but it's very unusual. There are limits on that.
So he has nothing to lose by appeal.
He probably has nothing to lose.
So you anticipate an appeal, no matter what the sentence is?
Yeah. Well, his lawyers have made it clear that they disagree with the theory that the government pursued in this case, that he was convicted for doing things that they say no other public official has ever been convicted of doing, and they intend to challenge that. And I would expect him to appeal vigorously. Yes.
But if he got the community service, which he's not going to get, he wouldn't appeal that, right?
Well, he wouldn't appeal that portion of it. He would appeal the findings of guilty. Yes, you do have the right to appeal the sentence as well as the conviction. Mm-hmm. But if he gets a really lenient sentence, no, I don't know that he would appeal that, but he certainly has made it clear he's going to appeal the findings of guilty.
Okay. What have I not asked you that you think is important for us to keep in mind for tomorrow?
Yeah, I think you've covered the waterfront, unless you can think of something.
Stand by for just a second.
Well, there would be a question, after the sentencing, if he's given any period of confinement.
Oh, that's what it, yeah, thank you. He's going to act, today he's asked to be put on, be released on bond pending the appeal. But the federal guidelines call for him to be incarcerated, but the judge can make that final decision, right?
Yes. The way that works is if the court sentences him to a period of confinement, then the court is required to order him into custody or give him a reasonable period of time to report. He can self-report. That is allowed as well. Sometimes people are given several weeks, sometimes several months. It just depends on the situation. But not a bond, not being kept on bond, just giving a deferred report date. Or the judge can say, yes, I will allow you to remain released on bond pending the entire appeal process. The difficulty with that is that the federal law that governs post-sentencing bail is, again, very strict. You have to, one of the things that you have to show is that there is some degree of likelihood that there will be some sort of a reversal of your conviction. You have to show that there are some meritorious arguments to your appeal that could result in a new trial. or an acquittal on the charges. That means the trial judge has to find that he, in spite of all that he or she did to make it a fair trial, may have committed some error that rises to that level. And that's a hard burden to overcome.
Have you ever heard of that?
I can't recall. Yes, there have been some, certainly defendants on bond on appeal. I can't recall in my own experience right now who they were, but it's not easy.
Well, your Bank of the Commonwealth, they didn't.
No, they were not permitted bond pending appeal.
Are they appealing?
Yes, they are appealing.
And they're in prison?
Yeah, they're most of the time, if I would say certainly just statistically, most of the time that a defendant is sentenced to confinement in federal court after a plea of not guilty, they are confined either at or shortly after the sentencing and not granted bail pending appeal. The standard is just so high. Now, this court may decide to give it. This court may feel that because of the uniqueness of the issues that there is some potential for differing opinions on the Court of Appeals and may feel in fairness he should be allowed to remain free. I would be surprised if that happened, but I wouldn't be shocked.
What do you think? What do you think his sentence will be?
I think that it's likely he will get somewhere between 8 and 9 years. That's my.
So that would be lower.
Yes, I think.
Why are you basing that lower?
I think, and I base it on experience such as in the Hamilton case, where I think that the judge is trying to strike a balance. And when you look at all of the factors involved in this case, his lifelong service and lifelong record of achievement and lack of criminal record is something, he's 60 years old, is something that is a significant factor in the formula. I think that in order to reflect that, there has to be some indication of a lesser sentence than the guidelines. On the other hand, I think what's going to hold it up at that level, not much less than 8 or 9, are the other factors we talked about, the public official, public corruption, and the need for the court not to be viewed as setting a double standard. I think the way that that balance can be struck is a sentence that's below the guidelines, but probably somewhere a year or two below that.
Anything else?
That's just my prediction, of course.
Is that anything else?
Nothing else.